What if the biggest threat to justice wasn't outside the courtroom, but sitting at the defense table? Right now, in a federal courthouse somewhere in the United States, that nightmare became reality. No Hollywood slow motion. No prior leaks to prepare the public. Just a judge, calm, experienced, unflinching, rising from her seat and giving the order that turned a routine trial into instant history. Marshals, secure the courtroom. Now. Files seized. Exits blocked. Seasoned attorneys suddenly flanked by armed officers, frozen in place as the gallery gasped. This wasn't a security breach or an outburst from the gallery. This was a federal judge declaring that the people sworn to defend the Constitution had allegedly crossed into felony territory. Witness tampering, subornation of perjury, obstruction, captured on secret audio recordings that exploded online just hours earlier. If you've ever questioned whether the powerful can manipulate the justice system with impunity, this story is your answer. Today we're going deep, very deep, into the full timeline of this unprecedented federal courtroom lockdown, the leaked witness tapes that triggered it, the human drama behind the robes and suits, and what it means for trust in American courts, corporate accountability, and the rule of law itself in 2025. Smash that like button if you're ready for the unfiltered truth. Subscribe and turn on notifications. This situation is developing by the hour, and I'll bring you every major update as it breaks. Section 1. The case that set the stage, building tension over months. To grasp why this moment hit like a thunderclap, we have to go back months, maybe even years, to the roots of the underlying trial. At its heart, United States versus Crestwood Financial Group. A sprawling indictment charging 6 senior executives with masterminding a multi-billion-dollar investment fraud scheme. The allegations are devastating. Ponzi-like structures disguised as high-yield private equity funds, falsified audits, layered offshore entities hiding losses, and, most infuriating, deliberate targeting of public sector pension plans. Teachers in small towns, firefighters nearing retirement, municipal workers who trusted the system. All saw decades of savings evaporate when the house of cards collapsed in late 2022. Prosecutors called it financial predation on a massive scale. Defense lawyers called it aggressive but lawful investment strategy gone wrong in a volatile market. The truth, as always, lies somewhere in the evidence, and that evidence was about to get explosive. The defense team was led by Langford and Pierce, LLP, a white-shoe firm notorious for never settling quietly and for weaponizing every procedural rule in the book. Lead counsel: Harlan Pierce, 58, former federal prosecutor turned high-stakes defender, known for razor-sharp cross-examinations and a reputation for bending rules right up to the ethical line, never quite crossing it, until now, allegedly. Presiding, Judge Victoria Hale. Appointed in 2011, she's handled some of the toughest cases on the docket: cartel money laundering rings, international cyberespionage, complex securities frauds. Legal observers describe her as the quiet storm, rarely emotional, always prepared, deeply respected by both sides for fairness. She doesn't perform for the cameras. She doesn't need to, but even Judge Hale's patience has limits. Early warning signs appeared in the pretrial phase.
A defense investigator was spotted lingering too long near a sequestered juror's family at a public event, dismissed as coincidence, but noted in the record with a formal admonition. Then a prosecution witness recanted key details mid-deposition, claiming stress-induced confusion. Prosecutors moved for sanctions, denied, but Judge Hale's written order carried a subtle warning. The court will not tolerate any appearance of improper influence. The real linchpin was witness Zeta, a former compliance officer inside Crestwood who flipped early, entered witness protection, and promised to deliver the paper trail connecting the executives to the fraud. Wire instructions, internal memos admitting creative accounting, emails discussing regulatory workarounds. Zeta's testimony was scheduled for a Wednesday. Everyone knew it could be game over for the defense. Tuesday night into early Wednesday morning, chaos online. Around 2:45 a.m. Eastern, encrypted file-sharing links began circulating in private legal journalist channels. Subject lines read things like "Crestwood urgent, do not forward yet." By 4:12 a.m., the files were on select Substack pages and Twitter/X threads, now under intense scrutiny for how they spread so fast. 3 audio files, total runtime 21 minutes 47 seconds, timestamp metadata matched call logs from Zeta's protected phone. These weren't government bugs, they were self-recorded by the witness, who later told investigators he grew suspicious after the second call and started hitting record. First recording 18 days pre-trial. Male voice matched to a senior Langford and Pierce associate. Zeta, relax, you don't need to remember every wire date. If something's fuzzy, that's fine, juries understand human memory. Just stay consistent on the big picture. It'll help everyone avoid unnecessary headaches. On its own, vague coaching. Combined with what came next, damning. Second recording, 10 days pre-trial, same voice, colder. Those summer transfers are radioactive. If they come up, just say you weren't in the loop. And listen, if this gets messy, it could affect people around you. Your brother's business license renewal is coming up, right? Nobody wants complications for family. Federal prosecutors classify this as a classic Section 1512 intimidation offense, implied threat to economic/family interests. Not a gun to the head, but the message lands the same. Third recording 68 hours before testimony. New voice, female, measured, almost clinical, matched to a billing partner. We've compiled your testimony guide, 32 pages. Key points, phrasing suggestions, topics to avoid. Study it tonight. If you deviate even slightly, we can't guarantee the Marshal's service maintains your current protection level. You know what relocation really means. Attached in the leak metadata, a scanned PDF titled Zeta Witness Preparation Summary. It included scripted responses to anticipated questions, red flag phrases to never utter, and alternative safe explanations for key transactions. By sunrise, the audio was everywhere. Legal Twitter erupted. Cable news booked emergency panels. Prosecutors filed a sealed emergency motion at 8:47 a.m. Judge Hale was briefed in chambers by 9:30 a.m. courtroom staff, later described her listening on a secure laptop. No visible anger at first, just focused intensity. Then her posture changed, shoulders squared. She looked up and said quietly to her clerk, "Clear the afternoon docket. We're going back on the record at 11:30. 11:29 a.m. courtroom doors open. Gallery already full. Victims' families clutching tissues, reporters with live feeds ready, a handful of law students who thought they'd see routine argument. Defense table. Pierce and 3 associates, laptops open, confident body language. Judge Hale enters, doesn't sit. She stands at the bench, unusual for her, and begins without preamble. This court has permitted, and will continue to permit, zealous representation within the bounds of law and ethics. What cannot be permitted is conduct that undermines the very foundation of these proceedings. She summarized the recordings without yet playing them publicly. Then the hammer, pursuant to the court's inherent authority and 18 U.S.C. Section 401, the United States Marshals are directed to secure this courtroom. No person shall leave. No document shall be removed from the defense table. All electronic devices in counsel's possession are to be preserved in place. 4 marshals moved instantly, coordinated, professional. 2 positioned directly behind Pierce and his team. 1 blocked the main public exit. 1 stood near the court reporter, eyes on the gallery. Pierce stood. "Your Honor, this is highly irregular, Mr. Pierce," she interrupted, calm but steel-edged. "You will be seated. This is not negotiable." Silence, measured at 13 seconds on the official transcript. A victim's family member in the back row let out an audible sob. A reporter's pen dropped. 1 associate's hands shook visibly. This was no symbolic gesture. The courtroom had become, in effect, a frozen crime scene. Officers of the court sworn to uphold justice, now under physical containment because evidence suggested they had betrayed that oath. Compare this to past flashpoints. The Chicago 7 trial 1969-70, Judge Hoffman gagged and bound defendant Bobby Seale, seen as authoritarian overreach against defendants, Watergate-era proceedings. Lawyers tied to Nixon's campaign faced obstruction charges, but never mid-trial courtroom lockdown by marshals. Modern megafraud cases, Enron, WorldCom, Madoff. Defense teams fought hard, sometimes unethically, but nothing approached audio proof of scripting testimony for a protected witness. What sets this apart? Direct, time-stamped audio evidence, not circumstantial suspicion. Alleged perpetrators, licensed attorneys, not shadowy intermediaries. Judicial response. Immediate physical intervention rather than referral after the fact. If appeals courts uphold Judge Hale's actions, law schools may soon teach the Hale lockdown as the moment federal judges reclaimed authority over courtroom integrity in the digital age. Section 5, Immediate Aftermath and Looming Consequences. Current status as of latest courthouse briefings. Courtroom sealed. Marshals maintain 24/7 watch. Witness Zeta under enhanced federal protection. New location, increased detail. 3 Langford and Pierce associates resigned within hours. At least 1 hired personal criminal defense before speaking publicly. Harlan Pierce remains in secured status at the courthouse, flight risk evaluation ongoing. One female partner, the alleged third voice, reportedly began cooperating, turning over devices. Tomorrow's 9 o'clock emergency hearing will decide. Mistrial likely without prejudice. Immediate criminal referral to DOJ's Public Corruption Unit. Appointment of conflict-free counsel for defendants. Potential contempt/sanctions against additional firm members. Broader fallout. 21 other active Langford and Pierce cases now face motions to withdraw or substitute counsel. Victims' attorneys preparing massive malpractice/class action exposure, potentially 9 figures. Chilling effect on future witnesses. If defense lawyers can allegedly threaten protection status, cooperation rates could plummet in white-collar and organized crime cases. For defendants, prove ignorance of counsel's actions or face new conspiracy charges, a legal nightmare, and the unanswered question fueling every sidebar conversation: who leaked the files, an associate with a conscience. A staffer fearing indictment, that source may hold the key to whether this becomes a single firm scandal or the start of a larger reckoning. This moment transcends one trial. It's the U.S. justice system confronting an internal betrayal in the most public, undeniable way possible. A judge who could have deferred, delayed, or delegated instead chose to act decisively, visibly, forcefully. In an age where cynicism about institutions runs deep, days like this remind us that accountability isn't dead. When evidence is this clear and the violation this profound, the system can still respond with courage. What do you think heroics stand for, justice or dangerous overreach? Drop your thoughts in the comments. They shape the discussion and help this reach more people asking the same questions. If this breakdown of the witness tampering scandal and federal courtroom lockdown gripped you, hit like. It boosts visibility, subscribe, and ring the bell. I'll drop a follow-up the second tomorrow's hearing concludes with every new revelation. Thanks for going deep with me. In a world drowning in noise, choosing to stay informed